Hello, everyone. I'm here to talk about an issue that's very important to all landlords when you've got a residential property. There's a new case that just came out January 30th, 2023. It's so new I don't even have a citation for it, but I was in court the other day on a landlord-tenant matter, and the judge actually printed it for the parties, and we're going to be arguing from that case in the future. And the legal issue is when you rent a property as is, right? So a lot of leases say you're taking the property as is, and the legal problem that's being raised in the case is that as is might violate the statute on a landlord's duty to provide habitable premises. So as a landlord, you have a duty by statute to provide a habitable property, right? That there's no conditions that prevent people from living there, such as utilities and heating and air conditioning and water and sewer hookups and these different kind of things, and secure doors and windows. And what happened in the case was that a landlord rented a property as is, and the property was in terrible condition. I don't have any clients that have properties like this, thankfully, but this was a terrible fact pattern. Literally no doors and windows, roof is leaking, dead rodents in the house, utilities not functioning, etc. There was even human feces throughout the home. I mean, it was a nightmare property. It was rented out as is. And the tenant brought a breach of warranty of habitability, and the landlord said, no, you signed an as-is deal. Well, the Court of Appeals said, not so fast. You can have an as-is, but it still has to meet the conditions of habitability. And if it's not habitable, this as-is waiver is not valid, and we're not going to enforce it. And you as a landlord are still going to be liable for providing at the delivery and continuing forward, the property must always be in habitable condition. So be very careful on your leases. I want to contrast this a little bit with, I want to document it too. So when you're delivering your premises, whatever your lease says, you need to be more careful about documenting the condition is habitable and all those factors in the statute are being met, and initial those right on your lease that everything is habitable at the time of delivery. And you might do some inspecting as you go along. Many landlords have an inspection and maintenance regime, and you want to always be documenting that your property is still habitable even after the fact, right? So that's one thing. Documentation wins cases all the time. That's the only way to win. Evidence. Okay, otherwise the court's guessing and you might look bad or sound bad. So you really have to be careful with that. Contrasting that idea, though, is a lot of times in commercial leases you might have two provisions, landlord's duties and tenant's duties as it relates to improvements. So say you're renting a white box, which is a definition of a retail spot that just has blank walls and a floor. And then who's going to make all the improvements inside? Well, the landlord might have some improvements to make. The tenant might have some improvements to make. It's kind of like that. So think of it in that context for your residential lease, and maybe you couch the terms differently and avoid this as-is provision, and maybe go with something else that's more related to it's accepted as habitable, right? The tenant acknowledges that the property is delivered in a habitable condition, and that they'll notify the landlord if something's not habitable, right? So you got a couple different things there. If there's any improvements that need to be made, I think you ought to itemize those in the lease, or things that are going to be delivered. So you might be having a property that's under rehab, and then when the tenant's coming in, a few things are going to have to be completed before they take over. So you would itemize those in the lease so that there's a record in writing what you are doing as an owner, as an investor, and a housing provider. And if there's something the tenant's going to do, and maybe as a concession for a rent abatement or something like that, fine. Put it in there that that's what the tenant is doing, particularly when these things relate to habitability. So you got to be very, very careful on this, and I'd caution you and maybe have us take a look at your lease, and we might do some revisions and edits and that kind of a thing. But brand new case, very, very important, and it's a trap for investors that they can't just say, hey, it's as is. You agreed. Just because you put it in the contract doesn't mean it's going to uphold statute or constitutional law. All right, that's it for today. Hope that was helpful. I look forward to hearing from you.